Good morning and welcome to our webinar, Current Issues in Environmental Law. This is the third in our series of talks on environmental law and policy, and in particular covering the provisions of the Environment Bill, which, although currently stalled as a result of the COVID crisis, is likely to be reintroduced, or at least its progress is likely to continue shortly. We're looking at a series of current issues. This morning, Heather Sargent's going to deal with an update on some recent developments in habitats. And in terms of the bill, Rob Walton QC will be covering waste under the bill, and Matt Henderson will be covering air quality under the bill. I'm David Elvin, Queen's Counsel, as you'll probably know. Would you just note, to start with, a couple of housekeeping points. Firstly, your microphones are automatically muted, so you won't need to adjust your local settings. We welcome questions throughout the seminar. Please submit them via text on the Q&A button, which you'll find somewhere on your screen. If you have a laptop, it's at the bottom of the screen. It may be elsewhere if you're joining by iPad or something similar. We'll seek to answer all questions at the end of the last presentation. If there are any outstanding when the session comes to an end, we will endeavour to answer them by a general email. If you lose your connection at any point during the webinar, and I appreciate there were problems with Zoom yesterday, which they say they have now solved, please rejoin the meeting by just clicking the original link again. The first paper, as I mentioned, is from Heather Sargent on the issue of habitats, and very appropriately, Heather worked for 10 months in the institutions of the EU, including for the final part of her time there in the cabinet of Advocate General Sharpston, who, as you will be aware, gave an important opinion in the Sweetman case. She also runs the informative planning law tea break videos on YouTube. And if you haven't signed up to them already, I suggest you do. They're entertaining and informative, and even better, concise. Heather, please start.
Hi everyone, as David said, this is the Habitats Update portion of the seminar. So by way of an overview, we're going to look first of all at the recent opinion of Advocate General Cocotte in the Friends of the Irish Environment case, and then have a look at the Court of Appeal's judgment in Plan B and Secretary of State for Transport, which is the decision on the airport's national policy statement and the third runway proposed at Heathrow. Then we'll quickly have a glance at the Brexit regulations, I think I'll have to refer to them in short, which are going to carry through the existing legislation post-Brexit. And then at the end, I'll just mention what I've referred to as the Finnish Wolves case for reasons that will, I think, become obvious when we get there. So dealing firstly with Friends of the Irish Environment, the Advocate General's opinion was delivered at the end of April, so there's no judgment from the Court of Justice itself yet. The issue in this case relates to Article 6.3, which of course requires consideration to be given to any plan or project that's likely to have a significant effect on a European site. And the specific question that the Advocate General has addressed is where you've got a development consent that's limited to a 10-year period, and it's proposed to extend that consent by a further period of 5 years, then does that extension itself amount to a new project so that it has to be assessed pursuant to Article 6.3? Or can you conceive of the original consent and the extension as a single operation so that no further assessment is necessary? The conclusion reached by the Advocate General is that further assessment is required under Article 6.3. The factual context here is that development consent was issued for a regasification terminal back in 2008. There was a 10-year time limit on the construction phase and no time limit, incidentally, on the operational phase, as you'd expect, but the development was never commenced. And so in 2017, an application was made and granted for a 5-year extension. The Advocate General notes that Article 6.3 requires the competent authority to agree to a project, only after having ascertained that it will not adversely affect the integrity of the relevant European site or sites. And in her view, the board, in extending the consent, agreed to the project by issuing the extension. The board argued that in the context of the EIA directive, the Court of Justice doesn't regard the renewal of an operating permit as being a development consent for a project, provided that there are no interventions involving alterations to the physical aspects of the site. But the Advocate General rejected that analogy, pointing out that project for the purposes of the EIA directive is more narrowly defined than it is for the Habitats directive. And in any event, on the facts of this case, because without the extension to the original consent, the intended works or interventions involving alterations to the physical aspects of the site couldn't take place, the extension here would be a development consent for the project under the EIA directive as well. The Advocate General then comes on to the argument as to whether the original consent together with the extension should be regarded as a single operation, because if that were possible, then having regard to the Stad-Pappenburg case, there wouldn't be a need for further assessment under Article 6.3. She considers the case law on situations where recurring activities were initially authorised under national law before the Habitats Directive came into force. And she notes that where there's an old project that was authorised for the first time pre-Habitats Directive, then subsequently applying the directive might entail a considerable burden. And so in her view, the project developer in those circumstances is particularly worthy of protection. But she points out that in this case, this isn't an example of an old project having been authorised before the directive came into force. And so in her view, there's much less reason to protect the project developer through the legal concept of the single operation. She also says that the effort required to carry out an appropriate assessment of the extension would be very limited, because one could essentially refer to the previous assessment and would only have to take account of any changes that have occurred since then. I have to say, personally, I think that's a considerable underestimate of the work that's likely to be involved. We come then to what seems to me to be perhaps at least the key factor in the Advocate General's conclusion that we're not dealing with a single operation here, which is that under Irish law, the terminal couldn't be constructed without a new development consent for the extension of the construction phase. So the situation is, in the Advocate General's view, not the same as where recurring activities are authorised by one initial development consent, because activities that recur identically on each occasion won't generally, in her view, have an additional adverse effect. And the Advocate General refers to the recurring maintenance works on a waterway that were recognised as a potential single operation by the Court of Justice in Stad-Pappenburg. It's worth noting, I think, that there's a suggestion at paragraph 48 and 49 of the Advocate General's opinion that even if some of the construction works have been carried out, that won't alter the position unless the need for an extension falls away, because by carrying out some of the construction works, the developer has secured the right to complete the development without then needing an additional grant of an extension. The Advocate General also finds support for her approach in the EIA directive, which establishes that where you need a decision to prevent an existing development consent from expiring, then that will be a new development consent, having regard to the well-known case of Wells. And she also points out that in practical terms, it's beneficial to require further assessment for an extension, because both the factual position and the legal position in terms of the applicable law might have changed by the time that the extension is sought. On the facts in Friends of the Irish Environment, there were also deficiencies in the initial assessment that had been undertaken for the 2008 consent, which meant that it was of very limited relevance in the Advocate General's view by the time the application for the extension was made in 2018. The other aspect of the Advocate General's opinion which is useful on the question of extensions to consent is the consideration she gives to the factors that the competent authority has to take into account when it's screening the extensions, so when it's screening the new project and concluding whether or not it's likely to have significant effects on the protected site. She says that the significance of the finding that the original project has obviously been found not to adversely affect the integrity of the relevant European site might be significant, but it depends on the reasons for that finding being reached. First of all, and this was particularly relevant in Friends of the Irish Environment, any gaps, by which she means flaws, in the assessment undertaken for the original project have to be closed. The new assessment also has to take into account any intervening changes in the project or in the habitats or species that are protected in relation to the site, and of course developments in scientific knowledge. And importantly, there's a need to update the assessment to include potential cumulative effects from plans and projects that have been consented since the date of the original development consent. So the key point here, I think, is that it might not be necessary to start completely from scratch, but that depends on how good the initial assessment was for the original consent, and of course how much has changed in the intervening period. So that's the Advocate General's opinion. We'll have to wait and see whether the Court of Justice agrees with her analysis in due course. I'm coming then to Plan B and the Court of Appeal's decision on the airport NPS litigation and the proposed third runway at Heathrow. Several of the grounds of appeal before the Court of Appeal related to the Habitats Directive, but none of them were successful. The first habitats question considered by the Court of Appeal is what's the appropriate standard of review to be applied when considering whether or not Article 6.3 or 6.4 of the directive has been breached. The Divisional Court held that the familiar standard of Wednesbury irrationality should be applied, relying on the decisions in Smith and Munither Gwent, and the appellant continued to contend before the Court of Appeal that the appropriate standard of review should be proportionality. The Court of Appeal rejected that argument and has held that the applicable standard of review is indeed Wednesbury irrationality. The 2 points to take from the reasoning are that neither the decision of the Court of Justice nor the opinion of Advocate General Cocotte in Cranest support a different conclusion, and also that the Court of Appeal has held that there's no reason to distinguish between the appropriate standard of review for Article 6.3 and the appropriate standard of review for Article 6.4. On Cranest, the appellant relied on the Advocate General's opinion because she'd said that there must be more intense review where there are particularly serious interferences with fundamental rights. But the Court of Justice accepted, sorry, the Court of Appeal accepted that the Court of Justice in Cranest did not accept the Advocate General's analysis, and the Court of Appeal noted that instead the Court of Justice had recognised a clear strand of EU case law that respects the discretion of member states to lay down procedural rules for the protection of EU law rights. And the Court of Appeal went on to observe that in its view the appellant had not shown how any fundamental EU rights had been interfered with, still less seriously interfered with. So on the facts in Plan B as well, the standard of review was actually academic, because the Court of Appeal held that even if the standard of review had been proportionality, the Secretary of State had been entitled to reach the conclusion that he did on alternative solutions under Article 6.4. And this brings us to the second issue relating to the Habitats Directive that's addressed in Plan B. As I've set out here, the effect of Article 6.3 and Article 6.4 of the directive is that where a plan or project will adversely affect the integrity of the relevant European sites, then it may only be consented if, amongst other things, there are no alternative solutions. The question for the Court of Appeal was whether the Secretary of State's rejection of the Gatwick second runway as an alternative solution for the purpose of Article 6.4, because it would not enhance the UK's aviation hub status, had been lawful. The Court of Appeal concluded that the Secretary of State's approach had been lawful. The Court of Appeal endorses the Divisional Court's judgment where the Divisional Court holds that in respect of a national policy statement, a proposed option won't be an alternative solution unless it meets the core policy objectives of the statement. And those objectives must be both genuine and critical. So they have to be objectives of the sort that if they're not met, then no policy support will be given to the proposed alternative. Importantly, you can't exclude an option as an alternative solution simply because in the policymaker's view there's another option, so the preferred option, which meets the policy objectives to a greater extent and is on balance more attractive. But on the facts, the Court of Appeal held that the hub objective had clearly been a genuine and critical objective of the airport's NPS. The next question addressed by the Court of Appeal in relation to habitats is whether the Divisional Court had been right to distinguish between alternative solutions under the Habitats Directive and reasonable alternatives under the SCA Directive, and again held that the Divisional Court had been correct. The factual context for this point is that the Secretary of State had ruled the Gatwick second runway out as an alternative solution for the purpose of Article 6.4 of the Habitats Directive, but the Secretary of State had kept the Gatwick second runway ruled in as a reasonable alternative under the SCA Directive. The Divisional Court concluded that that approach was lawful, noting that Article 6.4 of the Habitats Directive imposes a substantive obligation because you can't give development consent unless its requirements are satisfied, in contradistinction to the requirements of the SCA Directive, which is procedural in nature. The Court of Appeal, I think it's fair to say, focused less on the substantive and procedural distinction and more on the purpose underlying each of the directives. It noted that the purpose of the SCA Directive was to ensure that environmental information is considered and to secure public participation. So that's why all reasonable alternatives are required to be considered and consulted upon. In contrast, there's no duty to consult before a conclusion is reached that the requirements of Article 6.4 of the Habitats Directive are met. And in the Court of Appeal's view, it would have been unnecessary and inappropriate for the Secretary of State to have had to consider the Gatwick second runway as an alternative solution under Article 6.4 in circumstances where his judgment was that it didn't meet a core objective of the policy. The Court of Appeal notes that consultees had had the opportunity to argue that the hub objective shouldn't be decisive against the suggested alternative, so the Gatwick second runway, but that opportunity had been afforded to them under the SCA Directive in accordance with the purpose of that directive. And finally, on Plan B, it's worth noting that the Court of Appeal concluded that there was no need to refer any of these questions to the European Court of Justice, and as far as I'm aware, none of them are proceeding to the Supreme Court either. We come then to the snappily titled Conservation of Habitats and Species Amendment EU Exit Regulations 2019. As I said, I'm just going to call these the Brexit regulations. Now, perhaps unsurprisingly, given the fraught political background, navigating this legislation isn't straightforward. The key point is that although when you read the Brexit regulations themselves and by themselves, they say that they're already in force, actually they're not, as I've explained here. The intent behind the Brexit regulations is to maintain business as usual. The quote from the bottom of this slide is from the explanatory memorandum to the regulations. And what this means is that the existing domestic legislation will, for the most part, be tweaked so that it still works next year. So, for example, references to Natura 2000 are to be construed instead as references to the National Site Network, and references to member state territory are to be construed as including a reference to the United Kingdom, and so on. I've set out here the domestic legislation that's going to be tweaked by the Brexit regulations, so we'll focus on the 2017 Habitats regulations. First of all, a couple of introductions to note. The new regulation 3A4 and 94A. The effect of these additions is that the Secretary of State and the Welsh ministers are empowered to issue guidance as to the interpretation of the requirements of the directives, subject to consulting first with the appropriate nature conservation body, and the competent authorities must then, unsurprisingly, have regard to such guidance as has been issued. Then Regulation 64 of the Habitats Regulations is proposed to be amended. This is a tweak with a significant practical result, which is that it will be the Secretary of State or the Welsh ministers and no longer the European Commission that will give an opinion as to whether there are imperative reasons of overriding public interest. So I've summarised how that's to work. The JNCC has to be consulted and the devolved administrations or the Secretary of State as relevant, together with any other person considered appropriate. Finally, on the Brexit regulations, new regulations 143 to 145 are introduced, and these allow, in my view, for more than tweaks to be made to the pre-Brexit legislation. The Secretary of State and the Welsh ministers can amend the schedules to the habitats regulations, and for the purpose of applying them domestically, also the annexes to the directives, if it's considered necessary to do so in order to adapt them to technical and scientific progress. Now, those provisions, of course, include the lists of protected species and habitats, although in order for any such amendment to happen, the approval of both houses of Parliament in England or of the National Assembly in Wales is required. Finally, I just wanted to mention what I shall refer to as the Finnish wolves case, for reasons that are probably obvious from the length of the case name. This is a recent judgment of the Court of Justice that will be of interest if you're concerned with the law around issuing permits that derogate from the protections afforded by the habitats legislation, such as permits for hunting. So I just thought I'd flag that, but I'm not going to go into the detail of that this morning. So that's everything from me on habitats, and I'll hand over to Rob. Thanks for tuning in.
Thank you, Heather. Our next paper is on the bill and waste and resource efficiency by Rob Walton. All I'm going to say about Rob is that having studied history and English many years ago, though he claims it's not that long ago, he has now gone over to the dark side and for many years has practiced very successfully in planning and environmental law. So Rob, your turn. Please proceed.
Thanks very much, David. As you say, I'll be dealing with waste and resource efficiency. And just by way of introduction, what this new legislation will allow us to do is to take a major step forward in terms of our environmental protection. There's a clear potential for additional supply chain costs, and the legislation sets out a regulatory framework. So the detail will obviously be in secondary legislation. So the precise approach and the full impact won't be known until then. So how do we get here? Well, we had the 25-year plan published back at the start of 2018. And then at the tail end of 2018, December, we had the waste resource strategy published as well. And in terms of part one of the new act, what that will do is will empower the Secretary of State to publish strategic targets. And in terms of resource efficiency and waste production management, that will be a priority area. So we will have targets which will be the focus of these provisions that I'm going to outline to you just coming up now. So the bill, in terms of the basics, we have it's set out in part 3, which is broken down into 4 sections. We've got producer responsibility, resource efficiency, managing waste, and waste enforcement and regulation. And I'll be concentrating mainly on the first 2 of those, just touching very lightly on the last 2 towards the end. So producer responsibility, and what's this all about? Essentially, it's the polluter pays principle writ large, and this is an upgrade of the existing system. It's not a whole new product. Those of you who are familiar with sections 93 and 94 of the 1995 Act, the Secretary of State already has powers and has made regulations in respect of various sectors, but the government has seen fit to roll that out across other priority areas. So this, as I say, is an upgrade rather than a new product. So this breaks down, producer responsibility breaks down into 2 sections. We have got PROs, producer responsibility obligations, and we've got producer responsibility for disposal costs. And they both link through in the scheme of legislation through to Schedule 4 to start with in terms of what the where the detail is set out. So PROs, what have we got? We've got a general power, and again, this is directly analogous to the existing provisions, and across the piece we have the general power set out, and then limitations on that power and some duties on the Secretary of State. So I'll take you through those. General power here is the power to make regulations for imposing PROs on specified persons in respect of specified products or materials. And the regulations can only be made for these purposes: for preventing a product or material becoming waste, or reducing the amount of a product or material that becomes waste, sustaining a minimum level of, or promoting or securing an increase in the reuse, etc., of products or materials. What will the regs cover? So we also will be identifying the persons and products that will be subject to PROs. Registration, including publication and inspection. We'll have targets, and that'll be by weight, volume, or otherwise, in relation to the proportion of products that can be reused, recovered, recycled, etc. And the circumstances in which the payment of money will discharge a PRO. Additionally, though, we have compliance schemes. We have those already, of course, but just to remind you, that's a scheme under which PROs of members of the scheme are discharged by the scheme operator on their behalf. So it's an efficiency drive as much as anything else to minimise the resource burden on individual producers. The access, or the Act will say that they may be compulsory, but it seems to be to me to be almost inevitable that they will be, and of course there'll be registration provisions in respect of the schemes. Limits then the power to make regulations in respect of PROs. The Secretary has to be satisfied that the regulations will be likely to achieve the regulatory purposes, and we saw this a second ago, and then that they will be significant environmental or economic credits as against the likely cost of the imposition of the PROs. So a balance to be struck there. The burdens have to be imposed on the persons most able to make a contribution to securing those benefits, and that must be done having regard to the desirability of acting fairly between persons involved in society, and taking account of the need to ensure that the proposed PRO is so framed as to be effective in achieving the purposes for which it is imposed. So a balance there. So it's certainly scope for dispute, but a wide discretion on the part of the Secretary of State in terms of how the PRO should be framed. A brief mention on restriction of competition, because the Secretary of State must exercise the power in the way it considers best calculated to secure that the regs don't have the effect of restricting, distorting, or preventing competition, or if they do have that effect, the effect is no greater than necessary for achieving the environmental or economic benefits that we've referred to. Then in terms of enforcement, so the second part of the PRO regime, the regs will provide for an enforcement authority, compliance monitoring, records and information, powers of entry, and sanctions, including criminal offences. That brings me on to disposal costs. And here, going back to the pattern book, we have got the general power, and that is to make regs requiring the payment of sums by specified persons in respect of specified products or materials. Limitation is that they can only be made for the purpose of securing that those involved in shortening the supply chain meet or contribute to the disposal costs of the products or materials. And the overarching ambition here is that the producer is responsible for the payment of the costs of the product through its entire life through to disposal. So what are we talking about in terms of disposal costs and disposal? Disposal costs means such costs incurred in connection with the disposal as may be specified in the regs, and the disposal includes their reuse, redistribution, recovery, or recycling. And you can see here as to the breadth of the costs involved It may include the costs of collecting and transporting, sorting and treating, other steps preparatory to the disposal, or providing public information about the disposal or products or materials. So going back to that point I made at the start in terms of the potential for significantly increased supply chain costs, this is a very good example of that. Now, in terms of the administration, we'll have regulations covering that, and the enforcement will be as per the PROs. So then to the second part of the four subheadings, as it were, resource efficiency. General power again, making provision for the purposes of requiring specified persons in specified circumstances to provide specified information about the resource efficiency of specified products. And again, this is all about getting information out there so that people are aware of what the resource efficiency of products coming forward is and will be. Exclusions, medicinal, veterinary, medicinal and food products are excluded, but not the packaging for such products. So there's a clear target here for enhanced regulation in respect of packaging. What is information about resource efficiency? It must be relevant to a product's impact on the natural environment, and it must be information about, and then there's a great list of things, again, demonstrating the breadth of the government's ambition here. The expected life of the product, aspects of the product's design which affect its expected life, the availability or cost of component parts, tools, or anything else required to repair or maintain the product, whether it can be upgraded, and the availability of cost or costs of the upgrades. Any other matter, remember again looking at the breadth here, any other matter relevant to repairing, maintaining, remanufacturing or otherwise prolonging the expected life of the product, and the ways in which the product can be disposed of at the end of its life. Or, and again, see the breadth here, the materials from which the product's manufactured, the techniques used in its manufacture, the resources consumed during its production or use, or the pollutants released or emitted at any stage of its production, use or disposal. So all encompassing. Who will be faced? Well, again, it's a very broad target. It's anybody connected with the manufacture, import, distribution, sale or supply of the product. The Secretary of State's duties. Before making regs, the Secretary of State has to consult anybody the Secretary of State thinks is appropriate. Have regard to these matters. They are the extent to which the regs are likely to reduce the product's impact on the natural environment, the environmental, social, economic or other costs of complying with the regs, whether exemptions should be given or other special provision made for smaller businesses. And again, in terms of enforcement and sanctions, it's as per the previous provisions that we've already seen. Then the flip side of the same coin, resource efficiency requirements. So we've just been looking at the way in which information can be required about resource efficiency. This section is all about resource efficiency requirements in terms of the products themselves. The general power, again, this is making provision for requiring specified products to meet specified resource efficiency requirements. Same exclusions in terms of medicine, veterinary medicine and food, not excluding packaging. I wonder if anyone can hear the fact that my neighbour has started strimming in their garden. I hope it's not too intrusive. The definition is very similar in terms of the information definition we've looked at, but it's not identical. It's worth looking at the two definitions. They're slightly different, maybe imposed on the same class of persons. And by way of example, there can be prohibitions on sale or indeed supply unless the products meet particular requirements. And then there can be a requirement to provide information to others in the supply chain. So passing information on down to the people who will be, for example, supplying the product as opposed to manufacturing it. Duties. Secretary of State has to be satisfied that the product has a significant impact on the natural environment at any stage of its production, use or disposal. Likely reduction in the product's impact on the natural environment. Benefits would be significant as against the costs, and a reduction in terms of the product's impact on the natural environment couldn't be achieved as effectively without making the regs. So again, a decent slab of discretion there on the Secretary of State's part. And again, a concern for smaller businesses, there should be consideration of exemptions, etc., for those. Deposit schemes, again, this is rolling out a wide ambition in terms of making sure that products are reused rather than thrown. And this is a general power to make regs establishing deposit schemes. You can see actually there under B, one of the purposes is a reduction in the incidence of littering and fly tipping. I suspect that actually comes under, it's a subset really of A. But this government has a particular ambition to reduce the extent of environmental crime, including fly tipping and littering. And so it gets specific mention as subsection B there. It has teeth, it has enforcement provisions. This will have enforcement provisions which will provide for criminal sanctions, not for not taking your Coca-Cola bottle back, but in terms of non-compliance with the broader scheme once it's set up. Charges for single-use plastics, another clear policy ambition for this government. And this is giving the power to make regulations making provision for charging by sellers for items specified in the regulation. So it's the plastic carrier bag success rolled out across the piece. And the regulations may specify only items which are single-use, made wholly or partly of plastic, and are supplied in connection with goods or services. And a single-use item is defined as a manufactured item, which is likely to be used only once or used only for a short period of time before being disposed of. The third section is waste management, and I'll be very brief on this. Key points are that the regulations there will be amendment of the EPA 1990 to allow establishment of an electronic waste tracking system, and there will also be new provisions in the 1990 Act allowing regulation of hazardous waste. Matt, over to you.
Rob, thank you. Fortunately, turning you to audio seems to have largely dealt with the issue. Matt, let's see how we get on with yours. Matt Henderson is another person who's come over to the dark side, having studied English at university, but appears to be coping well with our devious ways as planners and environmental lawyers. Matt's going to deal with air quality under the Environment Bill. And those of you who have seen it will be aware of the fact that Professor Liz Fisher kicked off on air quality in our first session with consideration of Plan B. Matt, please proceed.
David, thank you. So there are, in effect, two thematic halves to the bill. The first half deals with the legal framework for environmental governance. I'll touch on this only insofar as it relates to air quality, because there are some interesting aspects there in respect of targets. And the second thematic half deals with specific measures for improving various measures relating to the environment. And for our purposes today, part 4 of the bill is the relevant part, and that has two subparts effectively. Firstly, a series of measures in respect of improving the existing regulation around air quality, and secondly, a series of new measures in with the environmental recall of motor vehicles. And my talk will broadly follow the same thematic structure. So very briefly, by way of background to the relevant parts, Section 16 of the European Union Withdrawal Act 2018 required the publication of a draft bill containing a set of environmental principles by the 26th of December 2018. That was achieved in the form of the Environmental Principles and Governance Bill, published on the 19th of December, but that fell with the general election. Then we get the new bill, which we have before us today, and which I'm considering. The relevance of that is that the first part is effectively a carrying through of what was in that earlier bill published back in December 2018. More specifically in respect of air quality, relevant to highlight, as Rob did, the 25-year environment plan. the concept of a green Brexit, and I've put a deliberate question mark there, but more specifically a goal of achieving clean air, whatever that may mean, and more specifically reducing pollution by publishing a clean air strategy, which we now have, consulted on in 2018, published in 2019, and also curbing emissions from combustion plants and generators, and that's the theme which comes through quite strongly in some of the provisions of the bill, which I'm going to talk through. So turning then to the first thematic theme, this is of environmental targets. I'm going to refer here to the clause numbers in the bill as originally published, but the health warning is that if and when the bill becomes an act, those clauses will very likely not be translated into the same sections. And there's actually a helpful comparison version on the Parliament UK website dealing with amendments. So clause 1 deals with the power to set what are called long-term targets by regulations, and that power is also coupled with a requirement on the Secretary of State to exercise that power to set at least one long-term target in 4 priority areas. And importantly for our purpose, one of those priority areas is air quality. What does a long-term target mean? What is it? Well, dealing first with the long-term part, it has to be for no less than 15 years. In terms of the target, there's 2 aspects to that. Firstly, what's called the specified standard. So it has to include an objectively measurable standard. And secondly, what's called the specified date. And that is a date for compliance. Now, Clause 1 sets those general long-term targets in the 4 priority areas, but specifically in respect of air quality, Clause 2 requires there to be a target for particulate matter. That's expressed to be an annual mean level of PM2.5 in ambient air. This is interesting because it's the only example of a specific target in the bill. All of the other targets come through Clause 1 in the general provision in respect of priority areas, and this illustrates the importance, I think, of dealing with PM2.5s and the need to have a specific target, therefore. Just dealing with an interesting point, ambient air isn't defined in the bill, it's to be defined by regulations. There's been some interesting representations on the bill by a series of professional bodies raising the question of how far this will include indoor air and what scope there might be for defining ambient air as including indoor air and to deal with the health problems related to indoor air quality. But otherwise, the target for particulate matter is in essence the same as for the long-term targets. There needs to be a specified standard and a specified date. Although unlike the need to have a period of no less than 15 years, the particulate matter target can in fact be for a shorter period of time, perhaps again reflecting the importance of the subject. Very quickly then, the process, this is dealt with in clauses 3 through to 6, just to pick out a few of the most pertinent points. Firstly, the target needs to be informed by expert advice. What is expert advice? A topical question, but here it means somebody who the Secretary of State considers is firstly independent and secondly has relevant expertise. The second point to note is that in setting the target, the Secretary of State must be satisfied that the target can be met. For my own part, I find this a slightly puzzling approach to set a target which you're satisfied can be met rather than set an ambitious target and try to stretch yourselves. Thirdly, there's the provision to revoke or lower targets, although I think it's important to note that in respect to the particulate matter target, that can't be revoked, that can only be lowered. If the Secretary of State wants to either revoke or lower a target, he or she needs to be satisfied that there'll be no significant benefit over and above the revised target of achieving the original target. So there's a comparison there. And secondly, that the alternative basis on which the Secretary of State can lower or revise is if there's been a change in circumstances, and as a result of that change in circumstances, the social, economic or other cost is disproportionate to the benefit. Turning then through to the 2 sub-themes. This is really dealing with clauses 69 through 74. Clause 69 and 70 are grouped together under the subheading air quality, and I'll deal with those first and then come on to consider clauses 71 through 74, which deal with the environmental recall of motor vehicles. So starting then with clause 69, the effect of this is to amend part 4 of the Environment Act 1995. It does that through Schedule 11 of the bill. There are a series of different amendments, and I'll run through them reasonably quickly. Firstly, an amendment to section 80. This requires the review of national air quality strategies, of the national air quality strategy, within 12 months, and then within every subsequent 5-year period. So it's introducing that new review mechanism. New section 80A. This includes a new reporting duty, which must be undertaken as soon as reasonably practicable after the end of each financial year. It requires the Secretary of State to lay a statement before Parliament, and that statement must do 2 things. Firstly, it must assess the progress towards meeting the air quality objectives and standards, and secondly, it must report on the steps taken to meet those objectives and standards. The third part is new section 81A. This imposes a duty on firstly, relevant public authorities, and they are public authorities defined by regulations by the Secretary of State. Secondly, local authorities in inland. And thirdly, county councils in inland, where there are also district councils for the area. What does that duty entail? It's a duty to have regard to the National Air Quality Strategy when exercising any function of a public nature that could affect the quality of air. So in principle, a broad duty. It'd be interesting for the part of local authorities to see the interaction with some of their functions which are not necessarily of a public nature, and how far this duty will apply there. There's certainly going to be grey areas that's worked through, and I'm thinking in particular of the disposal of land, for example. And there's also a power to designate relevant public authorities. So the breadth of people who may be, or organisations who may be included within this new duty is potentially very wide as well. Next amendment is to section 82. This enhances the present duty on local authorities to identify parts of its areas where objectives and standards are not being met. And it enhances it by requiring the identification by the local authority of sources of responsible emissions for the failure to meet those objectives and standards, the identification of any sources which are in a neighbouring authority's area, and also the identification, thirdly, of any relevant public authorities or the Environment Agency who have responsibilities in respect of the area where those responsible sources are emanating from. The purpose behind this is to encourage what we might say joined up thinking, cross-boundary cooperation in tackling air quality. And that links through into section 83A, which is a new section. There's a duty here on the local authority to prepare an action plan for its area. That action plan needs to secure the air quality standards and objectives for the area. It needs to deal with how the local authority is going to exercise its functions to achieve those objectives, and what measures the local authority are going to take in particular to get there. The local authority may revise their action plan at any time as a matter of their discretion, but there is an obligation on the local authority to revise it if it considers that further measures are needed. So, for example, intermediate monitoring suggests that they are reaching the stage which they need to be. And interestingly as well, in respect of county councils, where there's a district council for the area, there's a power there for the county council to refer the matter to the Secretary of State where they disagree with the action plan of the district council. Turning then to the new section 85A, this imposes a new duty on air quality partners to cooperate. The duty to cooperate, topical in a general sense in the planning world at the minute, such assistance as is requested by the local authority to its air quality partner. That's the substance of the duty. Who is an air quality partner? Well, they're identified by new provisions in section 82. And importantly, that duty to provide such assistance as is requested is subject to a caveat, and that is that the air quality partner may refuse the request if it deems it unreasonable. Again, a potentially grey area likely to give rise to some disputes. New section 85B, can take this relatively quickly. This is enhancing the role of these air quality partners in the production of action plans. There's a notification provision, a requirement also for the air quality partners to make proposals, and then for those proposals to be published within the action plan. And again, I draw attention to the fact that there's a power of the Secretary of State to direct the air quality partner to make further proposals. So if an air quality partner is being, let's say, less than ambitious, a Secretary of State could potentially step in there and has the power to do so if necessary. So that's section 85B. And on the same theme, noting the amendments to section 86, dealing with county councils, section 86A dealing with the Mayor of London, and section 86B dealing with combined authorities, which effectively transposes the substance of the new section 85B, which I've just talked through, in respect of those different persons and organisations. So turning then to clause 70, so still in my sub-theme of improving the existing regulation, clause 70 brings in a series of amendments to the Clean Air Act 1993. All of these amendments deal with the issue of smoke control. So firstly, a new section 19A in Schedule 1A brings into play a penalty for emission of smoke in smoke control areas in England. It also applies to moored vessels. There is a four-stage process, effectively, for this penalty. It starts off with a notice of intent from the local authority. The local authority can issue that if they're satisfied on the balance of probabilities that smoke has been emitted from a relevant chimney in a smoke control area in its area. A relevant chimney means a building or a furnace or fixed boiler to which a smoke control order applies. So that's stage one. Stage two is there's a right to object. The person on whom the notice is served 28 days to make any objection in writing to the local authority. After that, the local authority issues their final notice. This is stage three, and that final notice will impose a financial penalty, or can impose a financial penalty of between £175 and £300. Following that, there's the possibility of appealing to the first tier tribunal. The appeal is limited. It can be firstly on an error of fact, secondly because the decision of the local authority was wrong in law, or thirdly because the local authority's decision was unreasonable. And the first tier tribunal on that basis effectively reviewing the local authorities, decision, have the power to confirm, vary or quash that decision. Turning then to some further amendments, sections 19B, 19C and 19D are all new insertions into the Clean Air Act. And in effect, they produce a scheme of control of acquisition, a scheme of control for the acquisition and sale of controlled solid fuel in England. And this is derived very heavily from the consultation in 2018 on the Clean Air Strategy, and indeed the Clean Air Strategy itself in 2019, dealing with the issue of domestic burning in particular. The headline points is that there are three new offences. The first is an offence in respect of the purchaser, acquisition of controlled solid fuel for use. Importantly, there's no need for there to be demonstrated actual use. The second and third offences are those in respect of the retailer. The first is in respect of retail where the fuel is taken away from the retail premises. That is an offence which seeks to impose an obligation on the retailer to notify the purchaser of the first offence, which I talked about, the purchaser only offence, a notification issue there. And the third offence deals with retail by delivery. So this deals with the delivery to a building to which a smoke control order applies. In those circumstances, an offence has been committed by the retailer. The statutory defences to all of those three new offences dealing effectively with the reasonable grounds for believing that there's no smoke control order in place or that the fireplace in question is approved. Turning then to the new section 26A, an interesting but somewhat niche provision dealing with the reimbursement of vessel owners who've been required to make adaptations as a result of the new smoke control, as a response to a new smoke control order and the new offences which I've just explained. A series of criteria that the vessel owner needs to satisfy in terms of an absence of availability of mains electricity or mains gas, and also the need to have approval from the local authority before undertaking those adaptations. But assuming all of those criteria are satisfied, then the local authority is required to reimburse up to 70% of the expenditure on that vessel. Section 28A, again a new section, this is a broad duty on a local authority, requires them to have regard to any guidance published by the Secretary of State about the exercise of the authority's functions under this part. Now, turning very briefly to what I describe as the second sub-theme, this is in clauses 71 through to 74. All of this deals with the recall of motor vehicles and is in effect an attempt to enhance the powers of the Secretary of State to deal with goods and products which are having a negative environmental effect. So firstly, what's a relevant product? This is products that's specified or described in regulations. We don't have those yet, but we know that when the regulations do come, it can be a mechanically propelled vehicle or part thereof, an engine forming part of machinery that is transportable or part of that engine, or, and this is probably the broadest part, part of such an engine or machinery that's connected with the operation of such an engine. Now, within that, there's also needs to be a relevant environmental standard, and that's the standard which the product in question isn't meeting. And that's something, again, which is going to be specified in the regulations. And then finally, the environmental impact. This is particularly broad. It includes any impact on the environment caused by noise, heat, or vibrations of any kind, or release of energy or emissions resulting from the use of the product. So taking those three aspects together, the power of the Secretary of State is here potentially very wide. That becomes even more the case when you consider clause 72, which allows the Secretary of State to make regulations to give a compulsory recall notice to the manufacturer or the distributor of a relevant product. The notice requires, as it suggests on the tin, the return of a relevant product, but that such a notice can only be given if the Secretary of State has reasonable grounds for believing that the product does not meet a relevant environmental standard, as to which see the earlier parts on my previous slide. There's also the provision here that the Secretary of State may include supplementary requirements in any notice, and these can be particularly draconian, so it can include obvious things such as publication of any notice, but it can also include more taxing requirements such as the payment of compensation to a customer, the destruction or disposal of products, and the provision of information to the Secretary of State. Clauses 73 and 74 wrap up this subsection of this theme. Firstly, clause 73 allows the regulations to impose a duty on a manufacturer or distributor to give any information to the Secretary of State on notice, and it also confers powers of enforcement in relation to the giving of that information. And then clause 74 provides a series of interpretive provisions. The one that I've highlighted here is that of the manufacturer, and just highlighting the particularly broad scope of the definition, including anyone with involvement in the manufacturing process or a connection to such a person. So not only is the notice which the Secretary of State is permitted to issue particularly broad in its content, but it's also broad in its audience and the targets for that notice. So that's the final slide that I have. I believe we're now going to do some question and answer.
Thank you very much, Matt. Yes, we've got a number of questions. Can I just? I've responded in writing to one of the questions, which is that copies of the slides and a recording of the webinar will be made available in due course, probably later this week, and you'll be notified of where you can obtain copies of the slides and the webinar, which will be on YouTube. Can I just kick off by dealing briefly with the question about permitted development rights, then I'll hand over to Heather on the question relating to Plan B and reasonable alternatives. With regard to permitted development rights, they're qualified in any event by Regulation 75 to 78 of the Habitats Regs themselves. And if you have to screen in an appropriate assessment for permitted development, then the local authority, having taken the advice of the relevant conservation body, can only allow the project to proceed in a written decision under Regulation 77 if it meets the appropriate assessment test. So if the extension, if the PD right is an extension to an existing project, then it is subject to the Habitats Regs in any event. Heather, can I ask you to deal with the question of reasonable alternatives and whether Plan B impacts on that, please?
Yes, thanks, David. So the question was whether Plan B and the Court of Appeal's decision in that case sheds any light on what constitutes a reasonable alternative when preparing a local plan. And in particular, does it change the case law that gives the decision maker wide latitude on deciding what alternatives can be said to be reasonable? The short answer in my view is no, it doesn't change that case law. That said, I do think that the reasoning of the Court of Appeal that distinguishes between reasonable alternatives for SEA and alternative options for habitats would apply equally, probably to local plans as to national policy statements. So there might be grounds in producing a local plan for concluding that an alternative is a reasonable alternative for SEA and not an alternative option for habitats assessment. And I also think there's another strand of case law in the SEA context about objectives and how they can justify essentially the reasons for discarding alternatives from the analysis as you go along. I think some thought will need to be given actually to how the debate from the Court of Appeal in relation to the habitats regulations and the significance of the policy objectives in that context reads across and is or is not compatible with the case law on objectives and reasonable alternatives for SEA.
Can I also just add, for those of you who may have long memories or be as aged as I am, remember the Dibden Bay inquiry at Southampton about 20 years ago. The issue of all reasonable alternatives arose there in the context of a proposal by ABP to construct a new deepwater port. And the Secretary of State took a very rigorous approach to alternatives and said that because there were potential alternatives throughout the UK and not simply in the local area and not simply those studied by ABP, that the proposal did not get through the derogation provisions in what is Article 6.4. Next question, I think. Sorry, I've got the wrong window open there. We've been asked whether Section 4 makes the meeting of targets a legal duty on the Secretary of State, which could be enforceable in the courts by judicial review or possibly under the procedure contemplated with the setting up of the Office of Environmental Protection, although there's a reporting duty to Parliament by the Secretary of State. How do you see that as fitting together with the new legislative duties? For Rob, I think, isn't it? Hello?
I think that's actually for me, David.
It's for Matt, is it?
Dealing with the targets I talked about.
Oh, sorry, yes, it is.
At the start of my talk. I think the two have to be seen together. They are clearly linked. So that the general duty in Section 4, yes, in principle, potentially one which could be enforced through the courts, but it's a question of what the scope of any enforcement action should take, because I think this is where Section 5 comes into play. Section 5 gives imposes the duty on the Secretary of State to report to Parliament, including where the target has been missed, and that report needs to include the steps which are to be taken to remediate that fact. So if you were to try to enforce Section 4 alone, in circumstances where the Secretary of State had followed through the provisions in Section 5 and had taken the relevant steps in terms of reporting, then I think the actual scope for the court to take any action would be very narrow indeed. I'm thinking in particular the latter parts of the Client Earth litigation and the approach of the court there, Mr. Justice Garnham, in enforcing or potentially what the court felt comfortable in doing in terms of enforcement for the Secretary of State. And really here the action required in Section 5 is probably as far as I think the courts would be willing to go, i.e. to require the Secretary of State to put into place that plan to make sure that the targets are met and to remediate any issues which have arisen. So Section 4, I think, has to be read together with Section 5 for that reason. The question also said, is this also a question of political accountability? I think that's absolutely the case. And certainly the format of the reporting requirements in Section 5 laying before Parliament clearly underlines that.
So do you think that the creation of these multiple opportunities is going to cause more confusion than clarity?
I certainly think it's going to generate litigation from interested bodies who will seek to try to enforce what are actually a number of different duties on the Secretary of State at various different stages, and indeed on local authorities when we talk about action plans and the duties that they have there. I can certainly see that generating much heat, if not light.
And I suppose it's also possible that may interact with the Secretary of State's duty in formulating policy with regard to the environmental principles under Part 1 of the bill.
Yes, absolutely.
Yeah. Rob, can I turn to a question to you, please? And that is the resource efficiency provisions of the bill. What is the government trying to do, and to what extent does that help with the issues such as net zero and similar questions?
Well, I'm going to leave my video off, but in short answer, this seems to me to be a major opportunity in terms of the whole net zero ambition. Also, we've got the existing regime in place, and the government's been honest enough to say that it hasn't been entirely successful. And this, as I say, is an upgrade rather than a whole new product. It's going to be incremental. They can't line up every product at once. They've got their target areas, various things, including certain aspects of construction, bulky waste. We've got textiles, a particular problem, vehicle tyres. Those sort of things will come forward, and they've absolutely got their mind focused on sorting out waste in terms of packaging. I think the government is very aware that there is scope, given as they say in their in the strategy, that 80% of environmental damage is caused by, or could be avoided rather, through better product design. Then resource efficiency seems to be at the heart of obviously preventing environmental damage, whilst at the same time driving towards that net zero target.
On enforcement issues, Matt, a short one for you. Do you think that the fines that are being proposed by the bill are going to be enough to discourage? This is in relation to Clean Air Act amendments. Are going to be enough to discourage unlawful behaviour?
I think there's certain doubt about that. The target for this offence is effectively going to be, on the whole, a mixture of domestic and commercial premises. So a fine of that in a domestic context may well have an effect. In a commercial context, it may well have a much lesser effect, if any effect whatsoever.
I mean, is there scope for giving that more teeth, as they had to do with offences in relation to tree preservation orders, and make it much more an analysis of what the fine ought to be, having regard to the resources of the particular organisation breaching the regulations?
Yeah, absolutely. And I think also, just going to the TPO context, but Section 214A, a power to seek an injunction, that's the sort of enforcement power which might be appropriate here when you're dealing with that commercial context and ongoing manufacture or whatever it may be that's causing the issue.
Heather, can I come back to you, please? I've dealt briefly with the PD rights question, and there's been a follow-up to that, which we'll cover when we do our written answers. There are a number of detailed technical questions as well in relation to air quality and the like, and we'll seek to address those in writing because we don't have the time to deal with them now. But on a related question to extensions, what about the implications of Friends of the Irish Environment for ordinary extensions to planning permissions, i.e. the use of section 73? Sorry, Heather, you need to unmute yourself. That's it?
Yeah, just noticed that. Thanks, David. Yeah, I think the context over here, as contrasted with Ireland, is slightly different in that you can't use section 73 to extend the time for implementation. It seems to me that the likely resonance of the Advocate General's reasoning, if it's agreed with in due course by the court, is really the section on the significance of the original assessment. So I think it might help in arguing that where you've got a sort of previous consent for a scheme and you're now in effect trying to renew it and refresh it with a later grant of planning permission, then the assessment work that's been undertaken for the original grant of planning permission, if it was robust at the time and provided that it's updated to reflect changes that have happened in the intervening period, then it ought to be something that can be used, and there shouldn't need to be any, there shouldn't be a reason for starting completely from scratch. So that's how I see it keying in really to the English and Welsh context.
Can I ask you a question?
Could I just add in that one of the points that came out of the Finney seminar we did the other day was obviously section 73 forbids an extension of time. Section 96A doesn't do that in terms, and one of the questions raised there was whether actually one could use a section 96A to extend time, contrary to the express provision in ambition in section 73, and also modification orders, whether modification orders could.
Well, I suspect the short answer to that is, if there's any likelihood of needing an appropriate assessment, and we all know how low the threshold is, the should we bother to ask test, as Advocate General Sharpston referred to it in Sweetman, it takes you out of 96A anyway.
Absolutely, yeah.
But so you don't need to go very far to take it out of 96A. So I suspect that's not going to be too much of an issue. Can I just, sorry, I've forgotten the question I was going to ask. Oh yes, Heather, in terms of what Advocate General Cocotte says in Friends of the Irish Environment, in terms of looking at the whether or not your older appropriate assessment is appropriate either in terms of its data being up to date or its coverage of the issues, or actually dealing with the effects of the extension. To what extent is it going to be any different, actually working out whether you need a new appropriate assessment, going to actually differ from an appropriate assessment itself? Because presumably anything which is more than a couple of years old is going to need a fairly thorough consideration to ensure that it meets the objectives of Article 6.3.
Yeah, I think that's correct, particularly ecological surveys, which will be out of date almost inevitably, it seems to me, quite well before the planning permission itself expires. So that's, I think, why I'm quite sceptical as to the Advocate General's reasoning, particularly where she says she doesn't think, it will take a great deal more work. I just think, actually, you can't sit on these things, and you probably will have to do a lot of the work, and it is difficult in practice to see how much of it could be carried over for any sort of lengthy period of time.
Well, if you see what Advocate General Cocotte says in her opinion in the Holohan case in late 2018, or was it? Yes, late 2018. She stresses the issue of how up to date is the data and how well does it relate to the issues in question. So that must apply equally here.
Yeah, I think so. I think The analysis sort of on the face of it seems quite helpful in terms of saving work second time around, but in reality I'm not really sure it will take people that far, given the sort of limited expiry dates on ecological surveys and other sorts of assessment work.
Right. Well, I think if everyone doesn't mind, I think we'll wrap up there, given the time. As I said, there are a number of questions which we will answer in writing, as we've already promised. And as I said earlier, a copy of the presentation and a recording of the webinar will be made available shortly, and everybody will be notified of when that happens. So thank you very much for attending. The next environmental webinar, I think, is in the afternoon of the 8th of June and should include matters such as biodiversity gain and some other matters arising out of the bill. Thank you for attending, and keep safe.